Good evening, everyone, and welcome to tonight's class. So in order to have an orderly class, may I suggest to you strongly that your mic should be off. If you want to speak, you raise up your hand and then you unmute your mic, or at every point in time, apart from being the instructor, we shouldn't have any other mic on, except where someone has to speak, but there should be only one person mic on at the same time. Right. So last time we met, we started discussion of introduction to constitutional law and constitutions. We explained what constitutional law is. We explained what a constitution is. We look at some of the defining characteristics or that which makes constitution a constitution. Now we made the point that constitution is the supreme law. Constitution is the supreme law of the land. Or the highest law of the land. That is the most important law. And for that matter, all other laws, all other legal or juridical norms within the legal system derive their validity from the Constitution, the fundamental law. And we said that Constitution is not just when you have something written down in a document, but all the arrangements and all the practices that have crystallized, that governs how a particular polity, a particular country or state is governed in terms of the various organs and actors within the governance architecture or structure, how power is allocated, the various functions, the interrelationships, and all that. And we said that Constitution is the product of a constituent power. That is to say that Constitution is always birthed or is brought into being by some people or entity having authority so to bring it. And we said that in the case of Ghana, the people of Ghana are actually the constituent power. And we explained why that is so. And again, we made the point that Constitution reflects very important values, aspirations of the people. And we went back to looking at the preamble of the Constitution of Ghana. We look at the preamble of the Constitution of the United States, and so on and so forth. Now, we also started discussing sources of constitutional law, and we made the point that when we talk about the source, it refers to where we derive the legal rules, where we derive the law. So if you are talking about constitutional law, the things that make up the constitutional law, that make up the constitutional legal framework, that is the constitutional law. So where do we get those things from? Where we get those things from, those are like the sources. So that is where they are derived from. So we made the point that if we look at our Constitution itself, especially if you look at our preamble, yes, the ultimate source is the Constitution itself. But then if you enter the Constitution, for avoidance of doubt, we made the point that Article 11+1 of the Constitution has actually listed or provided what constitute the sources of law in Ghana, meaning that if anything is claiming to be a law within the Ghana legal system, we should be able to link it to any of the sources stated in Article 11, Clause 1. So you talk about the Constitution, you talk about enactment made by Parliament, you talk about orders, rules, and regulation made by any other person, the existing law, and then the common law. So when we decided to take these sources one after the other, we took the Constitution as a source, and we reiterated the point which I'd made again, that the Constitution is the supreme law of the land, and for that matter is the measuring rod for validity of any other law, any other thing within the legal system. If anything is found to be inconsistent with it, to the extent of the inconsistency, same shall be null, void, and of no effect. Then we also made the point that the Constitution is made up of various provisions, substantive provisions of 299 articles, and then the transitional provisions. The transitional provisions are so-called because we were under military government. So we were transitioning from military administration to civilian democratic dispensation. But we needed to phase out certain things, but it had to be done seamlessly, and the transitional provisions actually seeks to do that. Then we also talk about another source, enactments made by Parliament, and on that we reminded ourselves that if we look at Article 93 of the Constitution, legislative power is vested in Parliament. In other words, Parliament is given the power to make laws of Ghana. Of course, we also acknowledge that Parliament may authorize or delegate some other functionaries or entities to also make laws. But ultimately, the power to make law rests with Parliament and is vested in Parliament. So we saw Article 93, Clause 2, and we gave examples of some of the legislation that the Parliament has made. Then we also talk about orders, rules, and regulations. That is to say that Parliament may also, okay, so because some of you are not able to put your mic off yourselves, what I'm going to do is to lock all of you. But then if you want to speak, you raise up your hand and I will release your mic. I think that will bring some order. Unless, Nanama, you promise to put your mic off. Elsie, you put your mic off. Kweku, you put your mic off. Elsie, if Elsie can put his or her mic off, that'll be good. Yeah, okay, so that's fine. So I think, I'm sure every mic is off, so well done. So another source of law, which we mentioned, I'm just recapping what we did. That is why I'm moving very fast. So another source of law, which we look at, is the orders, rules, and regulations. And these are also known as subsidiary legislation. Subsidiary legislation. So when we say subsidiary legislation, let's see, okay, subsidiary legislation. Yeah, so subsidiary legislation. So, or also known as a delegated legislation. So there are various types, and we made the point that the basic idea is that Parliament does not have all the resources, all the time, and all the know-how to be able to make every detailed rules which need to be made for governance. So when Parliament makes parent legislation, they make like the main legislation. In that legislation, Parliament will create what we call the power for either a minister or a department or some other body to also make detailed rules or regulation in the form of legislative instrument, LI, or in the form of a bylaws, as for the district assemblies and so on. You will learn these things again in a course called Ghana Legal System and Legal Method. And those of you who are aware, I have a 2-volume work, volume 1, volume 2 on Ghana Legal System and Legal Method. And I think that source of law is treated in detail. So when you're doing legal system, you learn more about this. But at this stage, we are just mentioning it in brief because that is not like the main focus in the constitutional law. Of course, we also have what you call constitutional instrument, which is another form of delegated legislation. Oh, I'm just trying to erase this thing so that you can see clearly. Let me see. Yeah, we also have a constitutional instrument. For example, the Electoral Commission, we mentioned last time in classroom that the Electoral Commission will make detailed rules for conducting elections in Ghana. And those rules will be issued in the form of CI, or constitutional instrument. But one important point to note is that whatever form of delegated legislation or subsidiary legislation, be it rules, be it orders, be it regulations, Article 11 clause 7 requires that any such delegated legislation, any law which Parliament has authorized anyone to make, or the Constitution has authorized anyone to make, will have to be laid before Parliament and published in Gazette on the day that is laid, and it will remain laid for 21 days before it will come into force if Parliament does not, by 2/3 of all members, annul or revoke it. In other words, where subsidiary legislation is made, it must go through a simple process. First, it must be officially lodged with Parliament, and 2, when it is lodged with Parliament, it should be published in the Gazette. The Gazette is official document or official mouthpiece, like a sort of like a news letter, if you like, through which the state communicates to its citizens. So when it is lodged in Parliament, it will also be published in the Gazette for 21 days. If after 21 days, Parliament has not voted, and 2/3 of all MPs are saying that the particular LI or particular delegated legislation should be annulled or abrogated, then automatically it will enter into force and become binding. Yeah, so we give like examples. Then again, we said existing law is another source of law in Ghana. And by existing law, we made the point that having the 1992 Constitution in mind, we know it came into force that the 1992 Constitution came into force on 7 January 1993. And what that means is that before 7 January 1993, all the laws that were enforced in Ghana, right, before that critical date, those laws are grouped together as existing law. So existing law, all the laws that were enforced in Ghana before the coming into force of the 1992 Constitution, so before 7 January 1993, they are the existing law and they are part of the laws of Ghana. So we are talking about legislation made by the Third Parliament, the Third Republic, made during the Second Republic, the First Republic, the military decrees by the various military governments, the ordinances which were made during the colonial era, all form part of the existing law of Ghana. The caveat is that the existing law must the caveat is that the existing law must be in agreement with the letter and spirit of the 1992 Constitution. That is to say that should it happen that an existing law is found to be in contravention of the Constitution, then such existing law will no longer form part of the laws of Ghana. So for existing law to continue to be part of the laws of Ghana, it must be compatible with the letter and spirit of the 1992 Constitution. The thing is frozen. Just a second. Let me redo it. Let's reshare the screen. So we gave example of the existing law at 29, that Criminal Offences Act, the Sale of Goods Act 1962 at 137, and so many others. Interstate Succession Law of 1985, Penalty Law 111. All these are existing law because they were enforced before the coming into effect of the 1992 Constitution. Then we also mentioned the common law as another source of constitutional law and, for that matter, law in Ghana. And the common law here, we are talking about the common law of Ghana. The common law of Ghana is made up of what we call the common law, the doctrines of equity, and customary law, including those determined by the Superior Court of Judicature. Now, in legal system, we learn about the common law and how it came about, but suffice to note here that when we mention the common law, we are referring to the law which developed in England and Wales. After the Norman conquest, a group of invaders known as Normans, they conquered the present-day England and Wales. So when they conquered the present-day England and Wales, their king had the practice of sending some of his royal officials from community to community in order to go and resolve disputes and ensure peace and order in the realm. So they were going in circuit, moving around. They were itinerary judges. And wherever they went, they used the local custom and then the practices and usages over there to actually resolve various disputes which were presented before them. Now, they adopted the practice of recording their decisions, of recording the decisions that they were given in a book, so that if they went to a particular place and a case was brought before them, they will not actually reinvent the wheel. They go through their books and try and find out which decision they gave in a case which they have found to be similar to that which has been brought before them. And then they will apply that decision they arrived at in the previous case to the new case which I presented before them, which is materially similar to the one that they decided. Now, because of that practice of using past decisions, right, which we call stare decisis, using like the past decisions or precedents to resolve cases in the various communities that they went over a period of time. One could notice that a uniform body of law was applicable in the whole of the territory of England. And because there's a uniform body of law, like a law which is common to every place, and that's why the term common law came about. So the common law is essentially a judge-made law, right? A judge-made law in the sense that decisions of the court, which lay down principles for resolving disputes before the courts, are documented or compiled, and they are drawn upon whenever cases are presented. So that is like the common law. As I said, you learn details of this in the Ghana Legal System and Legal Method course, or if you read the Legal Method and Ghana Legal System textbooks. Now, in the course of time, people who were dissatisfied with the kind of justice the royal officials were administering decided to approach the king himself, because the king was seen as a person of good conscience, fairness, and justice, being a Christian leader at the time. So the king will listen to people's complaints, and he will bring his mind to it and give decisions which were found to be fair in accordance with good conscience and fairness. Over time, so many people were approaching the king. So the king appointed his chancellor, who initially was a bishop, to take over the role of looking into cases of those who had petitioned the king for intervention, especially those who had been to the common law court and were not satisfied with the outcome that they had. Now, decisions which were coming from those type of cases presented to the king directly and referred to his chancellor could be seen to be reflecting very good principles of fairness, equity, justice. So simply, they refer to the principles which were discernible in those cases as the rules of equity or principles of equity or maxims of equity. Now, for a long time, in England and Wales, there were two streams of court, one applying the common law and another applying equity. But in 1875, a legislation was passed called the Judicature Act of 1873 to 1875. And the Judicature Act sought to merge the common law and equity jurisdiction so that from 1875 onwards, there will not be two separate streams of court administering common law and equity. The same court can administer both common law and equity. Of course, by reason of our colonial relationship. When they also came here, they came here with their common law. For that matter, the common law and the principles of equity are very much part of our laws. And again, we have mentioned customary law. When we say customary law, they are referring to the rules of law which by custom and usage are applicable to particular communities in Ghana. And so if there's a dispute and then you go to court and you are asserting a particular rule as a customary law rule, for example, the courts will have to make a determination as whether what you are asserting is really a rule of customary law or not. Again, you learn details of this in Ghana Legal System and Legal Method, but suffice here to note that during the colonial time, customary law was not treated as law by the colonial government and the colonial courts. So where someone made allegation that something was a customary law, that was treated as a question of fact and not a question of law. Now, at this stage, let me bring to your attention that when it comes to dispute before court, right? Whenever you have a dispute or controversy before a law court, there are two key issues at stake. We have issues or questions pertaining to what the law is. And then we have issues or questions pertaining to what happened or what did not happen. So questions of fact and then questions of law. Now, for questions of fact are resolved by evidence. So it is responsibility of a person who is claiming that a particular thing happened or did not happen to bring evidence to persuade the court as a trier of fact to make a positive finding for that person that yes, what he or she is claiming happened or did not happen. But when we have, so that principle I've said that customary law is a question of fact was actually propounded by the Privy Council in a case known as Angu versus Atta. But again, as I said, when you are learning the legal system, we learn more of this. Now, when we had our independence and eventual Republican status in 1960, we had a Courts Act, which said that issues regarding whether something is customary law or not is not a question of fact, it's a question of law. Now, since it's a question of law, it is not responsibility of the parties to bring evidence to convince the court. The court will have to conduct its own research as to whether what is alleged is really a customary law or not. But as I said, we'll learn more about this in legal systems, so let us leave this. Now, just before we move on to the next segment of our introductory class, it is pertinent to remember that if you are talking about constitutional law in Ghana, your first week or first 2 weeks, if you not read any case at all, just to put you in the right frame of mind, it is useful to read the case of Marbury and Madison. Marbury and Madison is not a Ghanaian case. It's a United States of American Supreme Court case. And that case is seminal. When we say seminal, that is landmark case, or it is locus classicus, or it is a cause célèbre, meaning that it is a case of some pivotal importance as far as this particular area of the law is concerned. And why is it so with respect to Marbury and Madison? Now, in Marbury and Madison, as you have read by now, it's essentially asserted the power of judicial review for U.S. Supreme Court so that the Supreme Court could strike down acts of the other organs of government, including Congress, and say that this particular thing is against the Federal Constitution of the United States. Now, originally, if you look at the Constitution of the United States, there was no express conferment of such a power, but it had to take the ingenuity, creativity on the part of Chief Justice Marshall when he presided over the case of Marbury and Madison concerning last-minute appointment of judges by a government which was just about leaving power. Then to Ford versus Attorney General, you notice concerning appointment of Chief Justice and the procedure which was used in Parliament. And eventually, when it was challenged in the Supreme Court by Dr. Mwakutu Ford, it gave the Supreme Court the opportunity to reflect on our constitutional structure and also history. And Sowa, Justice Sowa made important observation, which have become a cliche or something which is oft repeated in various constitutional cases and discourses. So I want you to read that as well. And of course, Salah versus Attorney General, Buzia removal from office of certain public office holders, including Mr. Salah, and how that was challenged. And when that was challenged, it brought up the question of what is the legal effect of coup d'etat or revolution on the pre-existing constitutional order. Because don't forget that before Buzia came to office, we have had like the first the coup d'etat, which overthrew Dr. Kwame Nkrumah and his CPP government. So, question was, did the proclamation, that is the instrument of governance authority, which the military government actually made, did it operate to replace every source of legal validity in Ghana, including the pre-existing constitutional order? Yeah, so look at the case of Salah as Attorney General, and there's a scholar called Hans Kelsen who has written a lot about Grunum, and you notice that the one of the lawyers will go to the extent of relying heavily on the Kelsen's concept of Grunum to try and make his point, and how the Supreme Court at the time reject those arguments. J.H. Mensah as Attorney General is another seminal case I want you to read, just to put your mind in the right mood or frame. When President Kufuor came to power, when President Rawlings was in power, after the first term in office, election was held again, that he was retained. So ministers who had served in the first term and who had been retained or reappointed by the same president who had won the election again, did they have to go to the constitutional requirement of prior approval of parliament? In a prior approval, does it mean you should go to, if, for example, if you serve in the first term of the government, you are vetted and all that, and the same portfolio, you'll be retained to hold it again, must you go through the same elaborate vetting processes and all that before the appointment can be valid? So J.H. Mensah versus Attorney General, look at it. The NPP versus Attorney General, 31st December case. When Rawlings was the military leader, every year, 31st December, June 4th, he will lead Ghana to celebrate the coup d'etat which brought him into office. Now, when we return to constitutional rule, NPP, as the opposition party at the time, decided to challenge constitutionality of that and said that how can you use public resources to celebrate a coup d'etat which overthrew democratically and constitutionally elected government? It's unconstitutional. So they went to court, and then the Supreme Court agreed with them. So please read those cases as well, just to give you the initial appetite before we move on to more cases. But tonight, we want to continue with the distinction between constitutional law and administrative law. Before I continue, I will allow 2 minutes if anybody wants to say anything or ask a question so far. Just put up your hand and I will release you. Is there any hand up? No hand up. Let's see. Okay, no hand up. Okay. Good. So, what is constitutional law and what is administrative law? You've said a lot around this area, but now let us bring some kind of sanity to our discourse. So the point to note is that we don't have universally accepted definition of constitutional law. But if we look at various text writers, including Marshall, his work, Constitutional Theory, he makes the point that constitutional law is that part of national law which governs the system of public administration and the relationship between the individual and the state, unquote. So we made this point the last time that we met. So he is saying that, well, constitutional law can be understood as that aspect of the laws of Ghana, the national law, the municipal law, which focuses on the arrangements of public administration on one hand, as well as the relationship between the individual and the state. So for him, that is what constitutional law is. So constitutional law, therefore, is made up of those laws that regulate the structure and functions of the various organs of government and their relationship to one another and to the citizen. So you take our country, Ghana, where we are blessed with written constitution, and everywhere you go, anytime any discussion or debate is being undertaken regarding public matters, you notice that emphasis will be placed on constitutional principles or provisions, and also what the Supreme Court has said regarding some constitutional matters. And that has become very much part of our national life, so much so that if you open your radios and televisions, people are making any discussions anywhere, you go to workshops and all that, people are mindful of the boundaries which are set by the Constitution regarding what is permissible, what is not permissible, what is acceptable, and what is not acceptable. So therefore, we could flip the coin and say that administrative law is the law which determines the organization, powers, and duties of administrative authorities. So administrative law become, if you like, a subset of constitutional law, in the sense that the various organizations, the various public organizations or public institutions, okay, are set up as part of the constitutional arrangement. However, how these various public institution organizations, how they function in relation with governance at the micro level or at the individual level is the function of the administrative law. So in terms of contrast, we could say that whereas constitutional law is mainly concerned with the structure of the primary organs of government, the executive, legislature, judiciary, administrative law is concerned with the work of official agencies in providing services and regulating the activities of citizens. So that is the administrative law. So if, for want of better expressions, so whereas constitutional law focuses on primary organs of government, administrative law concentrates on secondary organs, let's put it that way, of of governance. Okay, so let's do a little bit of brainstorming before we move on to the next segment. How do you understand the difference between constitutional law and administrative law? Any hand up? Yes. Any hand up? I should call you. I hope you know how to raise your hand. Okay, I'll call you. Francesca, unmute and attempt the question. Okay, Francesca is not responding. Kweku, unmute and attempt the question. Okay, Linda, unmute and attempt the question.
Hello, sir.
Yes.
So, my understanding, constitutional law is concerned with structures or organs of government, while administrative law is concerned with secondary arms of governance, like the regulatory agency.
Okay. Okay, good. Can you give us a practical example to illustrate your correct explanation? Example to,
Okay.
yes. I mean, you are right, but I want you to illustrate it.
Okay. So let me gather my thoughts, please.
Okay, or anybody, Hassan.
Your Lordship,
Yes.
please the question again.
I think she attempted explanation of the difference between constitutional law and administrative law. So, well, let's hear your thoughts too. How do you understand the difference between constitutional law and administrative law?
Okay, so for constitutional law, I think, like we've said, it defines the structures of government, especially or particularly the various organs of government, the judiciary, the executive, and the legislature. On the contrary, administrative law deals with the state agencies, how they operate, and the framework that regulates their operations. That's how I understand the difference.
Okay, all right, good. Now, can one exist without the other? Emmanuel Tego, can one exist without the other?
Yes, I think they work together. I was going to say that, so for instance, when you take the electoral commission or the local government, realize that there are administrative bodies which have been given powers to operate. So they complement the work of the various arms of government.
Okay. All right. All right, good. So in practical terms, where do you think the boundary between constitutional and administrative law blur, if at all? In other words, blur means like they overlap. Valentina? Can you suggest any area or instance where you think that the boundaries between constitutional law and administrative law blur, they overlap? So that it's difficult to draw the distinction.
Well said, please. Because they work hand in hand, I don't see where they are destined to overlap because they complement each other.
Okay. Okay. Okay, any other body? Richard Socrates.
Hello, Doc.
Yes. Yes, proceed.
I believe the application of administrative law is dependent on constitutional law because the constitutional law is the structure that upheld the application of administrative law. That's my view.
So if you say constitutional is dependent upon administrative law or the vice versa?
The vice versa, administrative law is dependent on constitutional law because the constitutional law is the structure that permits the free implementation of administrative law.
Right, okay. All right. Good, so please think about these issues. You have them in your slides already. So let's move on. So we now move on to classification of constitutions. Do we have typology? Do we have some categorization of constitutions? Can we group constitutions into certain types? Well, we could say that we have a written constitution and unwritten constitution. So when we've already made the point that constitution refers to the arrangements, the institutions, the practices which relate to governance in a particular polity. Now, where you have a single document embodying these arrangements, then there is what we call a written constitution. And a written constitution is, as we have seen, a product of a constituent power, meaning that it's adopted at a particular point in time. So in Ghana, for example, we adopted our written constitution in April 1992, but then we chose for it to come into force per the PNDC law that should come into force 7 January 1993. Now, the United States have also got their constitution, which they adopted. So many countries, Nigeria, France, and all that. So you have like a single document where you can say that this is the Constitution of Ghana. But it is also possible to go to some other jurisdictions or countries where you will not be able to identify a single document which embodies or contains what we call the Constitution. But that notwithstanding, we can still see all the things which count as constitution being present in that particular country, either through scattered legislation, through various conventions and practices, and usage which have crystallized over time and all that. And a typical example is United Kingdom, England and Wales. And if we look at the literature, some scholars hold the view that written constitution is typical of countries that are coming from a certain historical experience. Either there has been war there, so they are making a break with the past and starting afresh, or whether they were under colonial rule, they're making a break and starting afresh, or whether there had been a military takeover of power, and then there's a return to civilian rule. So they're making a break with the past and starting afresh. Now, those observations are true for countries that have written constitution, and it's quite true for our country, Ghana. Because you notice that when we're moving away from colonial regime, we had our constitution. When anytime there had been a military takeover of government and a return to civilian constitutional rule, we have our constitution. But if you take a country like the United Kingdom, they have had a very consistent monarchical rule and so on. And for that matter, they don't have a single document equivalent to what we have or what the United States of America and other countries have. But they have elaborate and time-tested constitutional practices, principles, doctrines, usages. Another way of classifying constitution is to classify it as either flexible constitution or rigid constitution. So flexible or rigid constitution. Now, when constitution is classified on basis of this criteria, we are looking at the extent to which it is easier to amend the constitution. Is it relatively easier to amend the particular constitution, or it is profoundly cumbersome to amend the constitution? Now, the more easier it is to amend the constitution, then such a constitution may be classified as a flexible constitution. On the other hand, where it is relatively difficult and cumbersome to amend a particular constitution, we say that it is a rigid constitution. But we need to also acknowledge that the flexible and rigid divide or dichotomy we are talking about is not cast in stone. In other words, in the real world or in the world of reality, you are not likely to find constitution which cannot be amended at all. On the other hand, what seems to be the case and which is true for our country, Ghana, is that you get a constitution which has got certain provisions that are very easy to amend, and other provisions which are relatively difficult. So in Ghana's constitution, for example, we have the entrenched provisions and then the non-entrenched provisions. So the entrenched provisions are very difficult to amend, in the sense that you don't just have to go through the ordinary method, ordinary way of passing legislation. You need to involve the citizenry through referendum as part of the process before you can even drive the amendment process forward. So that makes it significantly cumbersome. Then we also have, so maybe what I would like you to do as part of your leisure, okay, is to take the 1992 Constitution and familiarize yourself with chapter 25. Chapter 25, starting from Article 289 to Article 292. So if we go to Article 290, for example, or maybe let's start from the 289, 2, for example. We are told that where Parliament intends to amend the Constitution, it must introduce a bill which is for the sole purpose of amending the Constitution and not any other unilateral purpose. So therefore, if Parliament wants to amend, let's say that the law relating to or bring certain new things, it cannot introduce constitutional amendment bill and add other things to that constitutional amendment bill. The constitutional amendment bill should be for the sole purpose of amending the Constitution, and nothing more and nothing less. Then Article 290 will give us examples of provisions which are entrenched. So we have like the Article 1, 2, and 3. They are all entrenched provisions. The whole of Articles 4 and 5 on territories of Ghana are entrenched. The whole of Article 11, the source of laws in Ghana that we discussed, they are entrenched. The whole of Chapter 5 of the Constitution, fundamental human rights and freedoms, are entrenched. All the chapters on the various organs of government, Chapter 8 on the executive, Article 93 and 106 on the legislature, the judiciary, Article 125, 127, 129, 145, 146, are all entrenched. These are just examples. So just look at the whole of Chapter 25 and know the entrenched ones and then the non-entrenched ones. And then know the procedure for the amendments. So as I said, for entrenched provision, Parliament will need to go through and they need to go through referendum to get a certain majority before it will come back to Parliament for them to continue with the process. On the other hand, for non-entrenched provision, you just comply with the usual mode of exercising legislative power and Article 106 of the Constitution, which is pretty straightforward. So the takeaway from the flexible versus rigid Constitution distinction is that the more difficult, the more cumbersome it is to amend the Constitution, we say that it is rigid. On the other hand, If it is relatively easier to amend, we say that it's flexible. Another distinction or another classification of the Constitution is whether it is presidential or parliamentary. Presidential or parliamentary. Are also known as whether it is monocephalous or bicephalous. Monocephalous or bicephalous. Now, a presidential constitution, so classified, is where the authority of government is vested in one person. So both the ceremonial functions and the non-ceremonial function, that is the real authority of the executive authority, is vested in one particular entity or person, as it were. And you don't have a situation where the president or the executive, wherever is the repository of the executive authority, is also a member of parliament. No. So the full executive authority is vested in the president. So it is monocephalous. So the ceremonial functions of the president and then the rare governmental authority of the president are all exercised by one person. Of course, the arrangement we have under our current constitution makes our constitution presidential system of government. So if you look at Article 50, I think Article 58, I've told you must always have your constitution beside you when you're having a constitutional law class. If we look at Article 58 of the Constitution, Article 58 clause 1, somebody should read it for us. Article 58 clause 1.
The executive authority of Ghana shall vest in the president and shall be exercised in accordance with the provisions of this constitution.
Good. And then look at Article 57 clause 1.
There shall be a president of the Republic of Ghana, who shall be the head of state and head of government and commander-in-chief of the Ghana Armed Forces.
Good. So by combined effect of Article 57 clause 1, Article 58 clause 1 of the 1992 Constitution, we can classify our Constitution as modeled on the presidential system of government, also known as monocephalous system of government. Now, the president is head of state, head of government. So head of state in the sense that he exercises the ceremonial executive authority. And then head of government, he exercises the actual, the rare governmental authority, as it were. Then we also have parliamentary, of course, not only Ghana. If you take America, United States of America, they too have the presidential system, and so many other countries. Then we also have what we call the parliamentary system, the bicephalous parliamentary system. This is where we have a split of executive authority, as it were, so that we have one person who is head of state and another person who is head of government. So the president or the monarch or whatever name they use will be the chancellor, will be like the head of head of state and will exercise all ceremonial powers, receiving visiting heads of states, ambassadors, and all that. Then we have head of government, usual designation, prime minister. Prime minister, or head of government business, as it were. So he will be like the head of government. Now, in Ghana, we've had this experience before under the Second Republic Constitution, where Dr. Buzia was the head of government, and we had Edward Akufo as the president. And if you go to France, they also have the same system. They have the president and then the head of government, like the prime minister. And I think the Côte d'Ivoire too has got the same. The constitution may also be classified as monarchical or republican. Now, where a constitution is classified as monarchical constitution, that is to say that the country is governed by a king or a queen, by a monarch. So powers of government are usually vested in the monarch. And in that case, the monarch will often be the head of state. And there'll be a prime minister who is the head of government, just as we have like in the UK. You know, we have like the monarch, this time like the king. Previously we had like the queen, who is like the head of state. And then we have like the prime minister, who is the head of government. And not only in UK, there are so many other countries also like that. You go to Swaziland, it's still monarchical. You go to, I think, Thailand. You go to Japan. You know, in Japan, they have only prime minister. They don't have like the president because they have like a king. And some other countries. Now, on the other hand, where a constitution is classified as republican, that is to say that the president or the head of state, head of government are elected or selected by the citizenry. Now, as you will notice, with respect to monarchy, it's not about selection by the citizenry. It's about whether you come from a particular bloodline, isn't it? If you were fortunate to have been born into a particular family where the monarchy is, then you become a monarch. But with respect to republicanism, where we actually select the person or persons we are going to invest or clothe with governmental powers. So in Ghana, for example, our first experience of republicanism was 1960. Now, prior to 1960, despite the fact that in 1957 we had become independent, between 1957 to 1960, when we were an independent country, we had monarchical constitution, so to speak, because the head of state was the monarch of United Kingdom. and we only had Prime Minister or head of government business, Dr. Kwame Nkrumah. Now in 1960, we decided to jettison all the monarchical trappings and so on. And we elected our own head of state and head of government. Okay, so before we move on, let's do a little bit of brainstorming. Nanama, this is for you. What distinguishes a rigid constitution from a flexible one? And what are the advantages or disadvantages of each? Nanama, try.
My lord, please, I didn't get the question. My network went.
The question is what? The first one. Can you see the screen? What distinguishes a rigid constitution from a flexible
Okay, so
one? And what are the advantages?
okay, so from what you explained, a rigid constitution is a constitution that is not so easy to constitution is one that is easy to amend. The advantages. Okay, so when a constitution is easily amended, I believe when a constitution is easily amended, I believe it facilitates processes. I believe that it will facilitate processes in governance.
Okay.
And then if it is on the other hand, the disadvantage is that if it is easily amended to, there will be a part of the constitution that might not be in favor, that may not.
Okay, all right.
That's
All right, thank you. Samuel Animfu, how will you describe the difference between a written and unwritten constitution? Or anybody set?
Lord,
Yes.
I am Lieutenant Colonel Samuel Kofi Ofosu,
All right,
counsel for
yes,
counsel for the defendant.
All right. Answer, proceed.
My lord, the difference between a written constitution and the question is
how will you describe the differences
yes,
between a written and unwritten constitution?
my lord, the written constitution is one that the various laws of the state are embodied in one particular document. And an unwritten constitution is one that the various laws of the state are written in many documents that embodies and come together as the constitution. For a written constitution usually comes up when there is a break in, for instance, governance. There's a coup d'etat, or people want to begin from a particular point going forward, setting out laws that will govern them or other provisions that they want to maintain going forward.
And then the unwritten constitutions usually has existed over time, and there have not been any need to change those laws. And that is why they come in many forms of documentations. Thank you, my Lord.
Right, thank you. Yes, I like your explanation. The only problem I have is when you said that like the laws of the country are written in the one document. And then that one is not wholly accurate. But we are talking about if you said like the laws relating to governance or the government structure are written in one document, then I have no problem. But if you don't qualify it, you say like all the laws, then that one.
Yes, ma'am.
Yes. All right, good. Yes, so do you think an unwritten constitution can provide the same level of legal certainty? Sabato? Yes, do you think it can provide the same level of legal certainty?
Yes, Your Lordship. I would answer in the affirmative.
Okay.
In the sense that an unwritten constitution does not connote that there are no predetermined rules and regulations. It is just that it is not codified in one document. And so to the extent that those rules and regulations are already known, then it would provide the same level of certainty that a written constitution would provide. Thank you.
Great, thank you. Okay, let's move on. Now, we now like to look at the relationship between international and municipal law. So, what is municipal law? Municipal law basically refers to the sum total of all the laws that govern a particular state or country. So, totality of the laws in a particular country is what we call municipal law. It's also known as national law, also known as domestic law. So municipal law is interchangeable with domestic law or national law. And as we have stated, they are the laws that regulate persons and activities within a particular territorial jurisdiction. So the assemblage of the laws in Ghana, we call that the national law of Ghana, or the municipal law of Ghana, or the domestic law of Ghana. And it's applicable only within the territory of Ghana. In the same vein, if you go to Nigeria, you go to Togo, you go to Germany, United States, you go to Iran, Russia, the laws within that territory, we call that the municipal law of that territory. So in Ghana, our municipal law is what we have here. If you look at 11 clause 1, all the things which are adumbrated constitute like the municipal law of Ghana, so to speak. So the Constitution, Acts of Parliament, the existing law and all that, they are all part of the municipal laws that govern the political entity we call Ghana. We also have international law on the other hand. Of course, international law is not free from contestation and disputation regarding even its legal status and value. Initially, it was referred to as like the law of nations, because from its very nature, it governs the relationship between states. the interaction between states on the international plane or arena. So that legal framework which governs that is international law. But maybe let me make a footnote remark. We have what to call, and if you look at the Ghana legal system, legal method, you also learn about classification of divisions of law. I think if you look at the volume 1 of my book, I've done some treatment over there. So you will notice that we have what we call like the public international law on one hand, and what we call private international law on the other hand. So private international law is also known as a conflict of laws. So therefore, public international law is that aspect of the national law which governs relationship between states and also between states and international organizations like the various multinational organizations, the UN, the WTO, the World Bank, IMF, and so on. Then we also have private international law known as conflict of laws. Now that one is that aspect of the law which governs disputes that have got foreign elements. And what do you mean by foreign elements? We are talking about a situation where there's a case before a court in Ghana. Let's say the case is about breach of contract. The contract was made in China. Goods were supposed to have been delivered in Nigeria. And payment is supposed to be made in Ghana. There's a breach. So the case is brought to Ghanaian court. If you look at the facts, you notice that there are various foreign elements. There are things related to China there, things related to Nigeria and Ghana. So issues may arise. Are we going to apply Ghanaian law? Are we going to apply Nigerian law or Chinese law? So how you navigate and unravel the appropriate choice of law which should be deployed, that is the role or the function of private international law or conflict of laws. So as part of your LLB studies, as you get to level 400, most universities, and I'm sure your university, GIMPA, should not be an exception, may have a course there which may be taught either as a elective or as a general course. But going back to public international law again, if you look at the explanation that we gave, you notice that the focus or the subject matter of it is the state and not the individual. So it's not about the international law, it's not really concerned about the state. So the actors of international law are states rather than individual subjects. But if we look at modern times, it is debatable as whether international law is not concerned about the individual as well, especially when it comes to various branches of international law, like international humanitarian law, which relates to war and refugees, for example, which seeks to provide some ground rules for combatants and non-combatants in the theater of war. What can be done, what cannot be done. Those of you who monitor the news, you see what is going on in Israel and between Hezbollah, Lebanon, Israel, Iran, and the whole crisis in the Middle East. What is acceptable, what is not acceptable, where you have the theater of war going on. So if you look at how humanitarian law, as well as international law, for example, has developed, as well as international criminal law, it may not be wholly correct to say that international law is not concerned about individuals, it's only about the state. But that is an academic debate which is ongoing. Well, international law has also got sources. In other words, where do we derive the rules, the juridical norms, the legal norms which constitute international law from? Well, if we look at Article 38 of the statute, which established the International Court of Justice, what you call it, the Hague Court, it lists sources of law which the court must have recourse to when it is hearing and adjudicating cases. And those sources are traditionally treated as the sources of international law. So if you look at Article 38, clause 1 of the International Court of Justice, that is the ICJ statute, it states, and I quote, "The court, whose function is to decide in accordance with international law, such disputes as are submitted to it, shall apply A, international conventions, whether general or particular, establishing rules expressly recognized by contesting states." So here we are talking about treaties. And as you remember last week when we met, we referred to Article 75 of the Ghana's constitution, which says that the president can enter into treaties subject to ratification by parliament and all that. So Article 38, clause 1 of the ICJ statute is also recognizing that in terms of sources of law, international conventions, which is the same as the treaties, are also source. Then international custom, what we call international customary law, is also a source of law. So when you do international law later on, you learn more about how international customary law is, for example, constituted, where you need to have uniformity of state practices regarding a particular matter, and various states do certain things, and they do it as if they have a certain legal obligation, as we call opinion juris. So where we have these two coming together, then we say that international customary law has been constituted. But as I said, you don't need to worry your head about those things at this stage. Just be aware that something like that exists. Then we also have general principles of law recognized by civilized nations. So that one is quite expansive. And then, subject to provision of Article 59, judicial decisions and teachings of the most highly qualified publicists of various nations as subsidiary means for determination of rules of law. So judicial decision, that is case law, to some extent, is also form part of international law. Okay, so just before we go, there is what we call monism and dualism, very important concept. So we are trying to look at the relationship between international law and national law, relationship between international law and municipal law. In other words, Ghana is a member of the international community. So what is the effect of international law under Ghanaian law? So those are the things that we want to look at. And for that purpose, two concepts have actually emerged. The concepts which have emerged are that we have the monism, or called the monist school, and then dualism, or the dualist school. And these schools, or these doctrine, actually dictate how international law is internalized or received in many countries of the world. And for that matter, we talk about international constitutional, I mean, quote and unquote, there's nothing really like that, but the question is, how does international law become binding under our national law? So those who subscribe to monism, countries that subscribe to monism, the view is that upon signing a particular treaty of an international character, the treaty immediately and automatically becomes part of municipal law of the country in question. So if a particular country is a monist country, as soon as their government signs international treaty, when the treaty comes into force at the international level, automatically it will also come to force in that particular country because the country is a monist country. And the monists, they recognize international law as part of domestic or municipal law because they think that there's only one legal order in the world. So there's no distinction between international legal order and then the domestic legal order. So for the monist countries, there's no special process by which international law is internalized or received in the municipal law by those so-called the monist states. Maybe Netherlands, for example, is an example of a monist state. We also have dualism or the dualist states, and they hold the view that before international law can become a part of national, domestic, or municipal law, it must be domesticated. It must be incorporated expressly into the local law or municipal law. So there must be a process of changing the international character of that international law in question by making them part of domestic law before same will be binding in the domestic or municipal law. And this is usually achieved by enacting legislation for that particular purpose. So look at Ghana, for example. We have mentioned, somebody should read, I think, Article 75. Article 75, somebody should read that for us. 75 of Ghana's Constitution. Yes.
Article 75. The President may execute or cause to be executed treaties, agreements, or conventions in the name of Ghana.
Yes, move on. Clause 2, 75 clause 2. Move on to 75 clause 2. Read, are you there?
The treaty agreement or convention
treaty.
executed by. Okay, go on.
Sorry. A treaty, agreement, or convention executed by or under the authority of the President shall be subject to ratification by A, Act of Parliament, or B, a resolution of Parliament supported by the votes of more than 1/2 of all the members of Parliament.
Okay, good. So Article 75 clause 2 is quite insistent that when Ghana signs any treaty or convention, same does not have force of law under Ghanaian municipal law unless and until Parliament has domesticated it by passing the necessary legislation or resolution, as the case may be. So on that note, Ghana is a dualist state. Ghana is a dualist state. But it is possible for some countries to be partially monist and partly dualist. You take the US, for example. In some matters, you can say that it is dualist. In other matters, you can say that it is a monist as well. I think we've already answered this question, so we will not belabor it, isn't it? How do we determine that Ghana is a dualist or monist state? We've already looked at Article 73 of the Constitution. We've also looked at the 75 of the Constitution, which was just read. So I would like you to look at the cases like Amon against Cass, Blackburn was the Attorney General, Monteson and Peters, Dove Development Company against the Carleton government. So try and brief them as part of your notes. I've provided just an extract of that, especially the Republic against the High Court, as part the Attorney General, in which the issue of customary international law, whether is applicable under Ghanaian law, came up. So I'd like you to read these the full cases, and then brief them as part of your notes. So maybe just before we go, you have this in your slide already. So I'd like you to think about these issues. How do you perceive the interaction between international law and national municipal law in your country? Which do you think takes precedence and why? Then should municipal law always align with international law, or is there a room for deviation? And what might be the consequences of such deviation? And finally, what do you think are the challenges and benefits of dualism and monism when considering the relationship between international and municipal law? So I'd like you to think about these issues, and then at our next class, we move on to our next topic. So unless there's any question, otherwise I'll draw the curtain down now.